Hi everyone, how are you? I'm Shalini and welcome to yet another video of mine which is on data processing agreements. This video would be very relevant for the startups who are struggling to sign the data processing agreements, for business owners, and obviously for the privacy professionals and the legal professionals out there. So just imagine spending hours arguing about the price with the vendor, but we almost end up paying almost no attention to just one document, and that could actually save your business from huge fines, which is the data processing agreements, which is often called as DPA. So if your company collects customer data like emails, names, or payment details, getting this agreement wrong could cost you millions. So let's walk you through what DPA really is and the important things that we must cover, and the real examples of how to negotiate the good one. Okay, so when businesses sign contracts with vendors, they often focus on price, services, and timelines. But we overlook a very critical document, which is a data processing agreement. So, a DPA is a GDPR required contract that sets the rules for how a vendor handles a personal data, such as a customer detail, employee information, or payment records. So, many businesses don't realize this. Okay, under the GDPR, the controller, that's you in this case because it's your business, is always responsible. So, even if the vendor makes a mistake, so, ignoring or rushing through your DPA signing can expose your organization to severe risk, including fines and reputational damage also. So, first we'll move forward and see what DPA really is. So, a data processing agreement, a DPA, is a contract between two parties. The business process owners and the businesses who owns the data means the controller and the service provider that helps to store or manage the data. That is the processor, okay? So think of it like this, as if you run a shop and store customer emails with a cloud service. So you are a controller and the cloud service provider is the processor. So in this whole video, we are going to see this example only. So GDPR is a very important and major privacy law. Say you need a DPA. So whenever you ask another businesses to handle customer data for you. So this contract tells us exactly that what they can do and the data that helps to make sure that both parties can keep personal information safe. Now we would move forward and see that why does DPA even matter? So now we will be thinking that, well, the vendor should be responsible for this, right? But no, wrong. Under GDPR, the controller is always accountable, means the businesses whose data is mishandled will be responsible. So if your vendor mishandles personal data and you don't have a solid DPA in place, so you could face regulatory fines. For example, if I take example, in 2021, the Data Protection Authority has reprimanded a company for using US cloud service provider without an appropriate DPA and transfer safeguards. Okay, so even though the cloud service provider processed the data in a wrong way, the company will be held responsible. So this is the repercussions, I would say. So in short, the DPA basically protects your business, and it's more than just a paperwork. It's actually a kind of shield, which is against penalties and damage to your reputation. All right, now we'll see that what are the key clauses that we must understand in order to sign the DPA. This is a very important part, I would say. So let's take an example, which I told you in the starting of this video, that is a SaaS company, a SaaS platform purchasing or delivering cloud-based services. Okay, so cloud-based service provider will be our processor, and SaaS company will be the controller. Okay, so first and foremost point which we have to look for a DPA is definition part. So the foundational clause sets out clear definitions of all the key terms used throughout the DPA. So for example, personal data, data subject, controller, processor, personal data breach, subprocessor, applicable laws, all of these definitions has to be clearly expressed. So definition should also align with the GDPR and the other relevant regulatory language also, to avoid any kind of ambiguity and to avoid any kind of interpretation issue. So, for example, I would take that personal data shall mean any information relating to identified or identifiable natural person, including but not limited to customer names, emails, and usage logs. stored by SaaS platform on behalf of client. So here in personal data, I have written down in my DPA specifically the usage logs of the SaaS platform would also be treated as personal data. Okay. Second clause would be the purpose, scope, and nature of processing. So the DPA must specify the subject matter and duration of the processing. So what we will say that subject matter and the duration of processing has to be specified. The nature and purpose for which the personal data is processed and the types of the data involved. It should also include category of the data subjects, such as if employees, customers, or website users are there. And the processing activities must also be specifically described. So for example, if you are doing collection, if you are doing storage, analysis, transmission, erasure, or whatever things you are doing, it is coming under processing activity, and you should define all of these things correctly in your DPM. If you'll take an example, so for example, subject to this agreement, the SaaS platform means your company shall process personal data of client, maybe AWS will take cloud service provider. So AWS's customer and employees is strictly for providing CRM and CRM analytics and support services until the expiration or termination of the subscription agreement. So this is what a clause would look like. Okay. Now, the third clause would be the rules and responsibilities. Now, we have to define the rules and responsibilities in the agreement itself. So, the agreement should clearly outline that the obligations and responsibilities of both the controller and the processor. Okay, so what we'll say, the controller is responsible for determining the purpose and means of the processing and must issue documented instructions to the processor. So, this we will write in our agreement. And we also can write that the processor must only process the data as instructed by the controller and must not use the data for its own purposes or share it with unauthorized third parties or subprocessor. Okay, so this can be a clause which we can write. Now another clause we would look is security measure. So the data protection agreement must detail what are the technical and organizational measures, which we also known as TOMs, for ensuring the confidentiality, integrity, and availability of the personal data, which is CIA of the personal data. And also like security specifications, which will include encryption, pseudonymization measure, what are the regular audit process, and if you have access control or not, staff training, incident response plans, if the company is certified ISO 27001, all of these things we have to write in our DPA. And processor must also provide evidences of compliance. For example, if the audits are done, then audit certificates have to be provided. So, and also the document of penetration testing. So we can write in our DPA that the processor should provide these kind of compliance evidences whenever the controller would ask for. So for example, audit certificates, documentation of penetration testing, etc. Okay, and the fifth clause would be the subprocessor clause. So if the processor has engaged a subprocessor, so a DPA must require that we will write that the DPA must require prior authorization from the controller or provide for notification or objection rights. Okay, and the agreement should also stipulate that all of the subprocessors are subject to the same data processing obligation as a processor. So we will write it down in the contract. And also the processor will fully liable to the controller for any breach of the obligation of subprocessor. So for example, how we'll draft this particular clause is the SaaS platform may engage cloud service provider for data storage provided that the SaaS provider is notified within 30 days in advance or may object in writing. So SaaS platform shall ensure that all of the subprocessor are contractually bound to equivalent data protection obligation. So this is how about we can draft our subprocessors clause also. Now another and sixth clause would be the data breach notification, very important clause. So every DPA should obligate the processor to notify the controller without undue delay. Okay, and often in contracts we define within 24 hours or within 72 hours upon becoming aware of the personal data breach. But what I would suggest is for the processor we have to keep the timeline of undue without undue delay, because then controller will have another timeline which is of 72 hours to inform to the supervisory authority. So it's better to put such a timeline for the processor that without undue delay you would provide us the information about the breaches. Okay. Now, we also should write in that particular clause is that the processor must cooperate with the controller to investigate, to mitigate, to report the data breach to the supervisory authority and the affected data subject in accordance with article number 33. We will write that. So if I'll say that how will you draft this particular clauses, that in the event of a personal data breach, SaaS platform shall notify the client within and within 24 hours or without undue delay of discovery, providing the details of the breach, affected data subject, mitigation, actions taken, ongoing risk assessment. So all of these things, okay. And also we would write that the SaaS platform will cooperate with the client to fulfill regulator and customer notification duties, because then the client will be having the duty of informing to the regulator. So we would ask the SaaS platform that you are gonna cooperate with us, okay. So the next clause would be the data subject rights and assistance. So we can write that the processor is required to assist the controller in facilitating the exercise of data subject rights. So for example, right of access, right of rectification, right of erasure, and right of restriction, and right of data portability. And we would also see that the data protection agreement should specify the service level communication, such as the deadlines for action for handling request from from the data subjects, and require the processor to notify the controller of any such request or complaint. Okay. Then another clause we would be looking forward to is return and deletion upon uh, and the another clause the another clause we would look is return and deletion of data upon termination. So, upon termination of DPA or the controllers, so upon termination of data processing agreement or at the controller's return request, the processor must delete or return all the personal data unless further data retention is required by the law. So this clause will specify the timelines and the methods of destruction, and also that they have to return our data, and will also require certificate of destruction to confirm compliance. So all of these things we have to write it down. Then the another clause would be the international data transfer. So whenever the data is basically transferred outside the European Economic Area, which is EEA, the data processing agreement must require transfer to be in line with the GDPR, okay, which is chapter number 5. So we have to see the clause for the international data transfers, that the agreement should address the legal mechanism for the cross-border data transfer and the data protection standards in the receiving jurisdiction. So for example, if the SaaS platform stores or processes personal data in the jurisdiction which is outside the EEA, so if the SaaS platform stores or processes personal data in the jurisdiction which is outside the European Economic Area, we would say that transfer shall be made solely under the approved standard contractual clauses or equivalent adequacy decisions. So the platform will regularly review the third country data safeguards and provide compliance assurances to the client also. Then another clause would be the liability and indemnity clause. So every data processing agreement should specify the liability regime, which will include caps and which will also include limitation in relation to breaches of the data protection obligation and the regulatory fines. Some agreements require that the processor to indemnify the controller for direct damages, regulatory fine, and third-party claims arising from non-compliance. So, which is subject to agreed limits and exceptions also. Then the another clause would be audit rights. So we would write that the controller has the right to audit, right to inspect, and to obtain documentation regarding the processor's compliance with the data protection requirement. And in the DPA, we would also outline the scope, frequency, and the manner of such audits, such as we will do annual audit, we will do half yearly audit, etc. And anything related to confidentiality and operational terms, we will also highlight. Then another clause would be the duration and termination clause. So, which will say that this clause particularly specifies that what is the effective date and validity period of this agreement. Okay, and very important. And along with the other conditions for termination. So maybe if the breach happens, we will terminate this DPA. So if the change in law happens, then we will also terminate this. Or any unsatisfactory audit happens, then we'll also terminate this DPA. And we'll also include some instructions for data disposition, like how the data will be disposed, how it will be transferred to us, and how you will be deleting the data upon the termination of the agreement. All right. The 13th clause would be the documentation and record keeping clause. So in the DPA, we would write that DPA in so in the DPA, we would write that it requires precise documentation of the data processing activity. So we would write like that the processor is required to document, means maintain ROPA for all the data processing activities, including logs, incident reports, etc. Okay, so we would write like the SaaS platform would maintain appropriate records of processing activities, which is accessible to the client and regulatory authorities upon request. So, including processing purposes, data categories, recipients, and relevant security measures. 14th clause would be amendment and integration. This would be the last clause I would be talking about. So in the DPA, we should state that any kind of amendment procedure for any legal changes. So for example, any changes in GDPR or any other new regulation comes by, or any court decision comes by which is affecting our DPA and relationship to the main SaaS agreement. So we will change that. So for example, the DPA may be amended by mutual written agreement to comply with any kind of changes in the applicable law. So in the event of any conflict between this DPA and the main subscription agreement, the DPA shall be in control. So we can write it like that. Okay, so this is how we basically write down the clauses, and we also negotiate the clauses upon our terms. Now I will come and see that what is the negotiation skill in the DPA. So here is what basically negotiation looks like. So if the agreement says that we will notify you as quickly as possible about the breaches, so this is not done. Okay, ask them to be very specific. So for example, by what time period you are going to inform us. So for example, in 48 hours and 72 hours, you have to have a particular timeline in the DPA. So this is how you negotiate. Another thing we can say that if our DPA is saying that we can hire sub-processor without notice. So if processor is saying that we can hire sub-processor without notice, so what we'll negotiate is we'll negotiate for at least so we will negotiate is that you have to give at least 30 days of prior information, so that we will not be surprised that a new subprocessor is there. So this is how we negotiate the terms of the DPA. Now we will talk about the bottom line. So there is a takeaway for this, that a data processing agreement is not just a legal fine print, it is actually a backbone of our data processing strategy. So it will define that what vendors can do, what vendors can't do. It also sets standards for security and breach handling. And it will also ensure that if something goes wrong, you are not left holding the bag, right? So next time, whenever you are handling any standard DPA, you will not just sign it. You have to read it, you have to question it, you have to negotiate it also, because the regulators won't accept that but what if my vendor messed up as an excuse, right? So if you are a controller, if it is your data, then it is your duty to sign the DPA and to say to the vendor that no, vendor, you have to sign the DPA according to my terms, because at the end I will be responsible, right? Now, at the last of the video, if you like to have a checklist where I'll be giving you the DPA template, and I'll be writing the most important clauses of the DPA, and I'll also be giving you that what are the negotiation tips of that particular clauses. So drop a comment in the comment section below, and I'll be sending you across. Thank you so much.